Are you able to hear me, Greg? No. Greg, are you able to hear me? I can't hear you though. Hold on. I think I think it says you're muted.
I'm muted on my.
Okay. All right.
I am present.
Okay. All right. So first thing we say is close all windows. You don't want anybody to accidentally see on your computer.
Mm-hmm.
Okay. And then load your PowerPoint
Mm-hmm.
through your, okay. And then you're going to click to view the PowerPoint slideshow from the first slide.
Yeah, I got that. That's already up and running.
Okay, so wiggle your mouse on your screen where you see me, and you'll see a toolbar pop up at probably the bottom with a green button that says share screen.
Share screen. Yeah, you want me to do that?
Yep. And then you click it and you're ready.
I'll do screen one clean. Yeah. So I don't need to do I need to share the cam or no?
No.
Okay.
We don't normally, because now Zoom's having issues with so many people using it. So out of courtesy, we don't. You can if you want to talk to people, but we don't encourage it.
I wasn't planning on it just because I'd have to look at this screen to do that, and I don't usually look at my laptop screen. I look at my large screen that I have here. So
with your notes, yeah.
Yeah, so it has all the slides. So let me just make sure. So share computer sound. No, I don't want to do that, and I don't want to. Okay, so. That's what you should see.
I see your PowerPoint with, it says next slide. Do you want to go into the PowerPoint view?
Oh, are you? Oh,
yeah, I can see all that. So you got to make it look like you're putting it on the screen. So you want to view it from, the whole screen up there.
That's weird. Why would it do that?
Hold on, I'm moving mine over here so I can see you.
I thought, oh, I'm sorry. I clicked on the wrong screen. That's why I wanted screen 2. Never mind.
Okay.
I literally clicked on the wrong screen.
There we go.
This is what I would show.
Okay, good. So now when you're talking, when you can move it at your leisure. I like it better so that way you don't have to go next slide, next slide, right? So yeah.
I do this all the time. Yeah. So I should be able to move through this pretty quickly. You're going to take the first couple, or someone at SILA Foundation is going to
Cindy, well, hopefully she always comes in like a minute before we go live because she always has a meeting right before this, and she's going to introduce you in her kind, sweet, wonderful way. I love the way she is. So she's going to introduce you, and then she's going to let you take it from there. Okay. And then if you notice the last few slides, when you go into the SILAFoundation slides, she'll talk really quick about that little, I can't remember what we put in there.
Yeah, the stuff.
The limited time offer. It comes on there. Yeah. And then,
okay.
I guess. Yeah, I guess she'll talk about that. Yeah, I'm not sure. Anyway, so there's that. And then you go to thank you after that's done, if you don't mind running that part right there. That's
fine. That's not a problem at all.
Okay.
Is there a way to go to the beginning? I literally have to click on everything. Fantastic. So, and my last question would be, I am not planning on taking a lot of questions in this environment because most of them will probably be legal or I'm assuming this will be recorded, and even if the foundation doesn't record it, somebody could record it and it's open to the public. I don't want to risk this coming back on SILA or the foundation.
Do you want to disclaim that then? Say when you give because normally we leave it up to you. Most people ask questions during, but we don't address them to the end.
Yeah.
So what we could say, if you have any questions, you can send them to SILA support, and I can put it, and then we can address them as they come in and screen them.
Yeah, I was gonna, and I'm thinking maybe if we send them to, most of the background check questions that we take are usually addressed within the forum because it allows not just me, but other members of the task group to, to discuss them before it's answered. So,
well, then maybe, you can say if you're not already part of this group, shoot Diana an email and let them know you want to become it. Or if you are, we address the questions that you have today on that forum. So please don't ask them today, normal and during the webinar. Please take your questions to the forum. And actually that was good because we want to drive them to there anyway. Because we want that to be a reference, and it's hard to get people to do that.
Do you want me to get the forum on there or no? Is there a link for the forum?
No, if they have problems, they'll contact us. We'll direct them because a lot of people don't know, and then other people do. So you don't want to assume.
That's fine.
Right.
Works for me. Okie dokie then. So I'm just gonna stay back at the, are we in like a presenter room right now, or can everyone see
Yeah,
this?
I'm going to back up real quick and tell you what we're doing. What we do is when Cindy joins in and
Mm-hmm.
she'll say hey to us, and then it'll be right at 3 o'clock.
Mm-hmm.
And then I will say I'm going to go live, and then she's going to wait for about um, 20 seconds of
Yeah.
dead space, because it's everybody's slowly they're falling into the bucket for this webinar. And once all of our attendees that are registered are in this bucket, which if you wiggle your mouse, you'll see that right now there's only 3 participants. Who's a third? Somebody's on here with us. Anyway, that you can drop it in there, and then we start speaking. So then she'll introduce you. There'll be a dead pause there, so I don't think you lost us. We're purposely letting people drop in. So, and
Okay.
then that's when Cindy will introduce you, you will take off, and then she'll pick it up at the end, and then we'll say bye-bye.
No problem.
Okay.
No problem at all. All right. So, well then I'm just going to mute my screen then, or mute my my mic then for the time being, and I will not plan on engaging until 1 or 2 minutes after.
Okay. So, well, can you do a sound check with me about 5 minutes till, or when
Of
Cindy
course.
comes on, just to make sure she can hear you too?
Of course.
Okay. And then you can mute. Okay. I'm going to go mute too, but I'll hear you if you need me. Okay.
All right. And I'm still
Okay.
sharing screen. Are we okay with me sharing screen right now?
This is perfect. I really like these screens, by the way. They're really nice. So.
Oh, good. Yeah, I mean, you guys helped me out on it. So, all right.
Very
Awesome.
nice.
All right.
Okay. All right.
Thank you.
Mhm.
Hey, you guys, it's Cindy. Is everybody on?
Cindy, I am present.
Hey, Greg, how's it going?
All right, how are you?
I'm good. I'm going to introduce you. Anything you
Hey, guys, there were some changes in Zoom, and we're live right now.
Oh, dear.
So I just wanted to let you know that at 3:00, we could everybody be automatically dumped in because we only have 12 people. Hi, everybody, if you can hear us.
Hi, everybody.
So we're tested, Cindy. Everybody's audio is perfect. Greg's ready. So at 3:00, if you want to do the intro.
I will do
And
that.
I was worried that the password might have issue. Hopefully no one has problems with that. Real quick, Greg's wanting to do questions via the forum in the SILA on the SILA website so that the whole task group can answer them as a group since they are financially related. So that's going to be what's different on this webinar. Is that okay,
So
Cindy?
we're not going to do questions in Q&A or chat?
Nope, send them to Diana Capes or post them on the forum.
All right.
Okay. All right.
Anything that does come in on the chat, though, we can always move it over there. We've done that in other presentations too, and on-site stuff or conference stuff as well. So,
Okay.
All right. I'm changing my instructions accordingly. Okay.
Sorry. And we'll
No,
work
it's
through
fine.
these bugs next month. I know that there's a practice button room you have to have now because of this people, hijacking people's Zoom sessions.
Right.
So yeah. So now I know that changed because I don't see live. So, okay. For those listening, we'll be back live at 3. Are you two okay?
Totally fine. See you at 3.
Okay. All right. See you guys at 3.
Okay, hi guys, greetings. Welcome to the fourth SILA Foundation webinar of the 2020. I'm Cindy Davidson, Education Trustee for SILA Foundation, and it is my pleasure to welcome you today. Before we get going, a couple of housekeeping tips. We're gonna keep this to 1 hour, and if you have questions as we go through, we are going to ask this time that they be submitted through the SILA website, through the SILA forum, because this webinar is really based on some research that's being done by the SILA agency and carrier subgroup. So our presenter today, super excited to welcome Greg Kirsch, who is the Chief Operating and Compliance Officer for Applicant Insight No More Forums. Greg is also chair of the Background Investigation Task Group, which is part of the SILA agency and carrier subgroup. That's a lot of nouns, but those of you who are SILA members can keep that. I have faith in you. Greg's going to lead us through the results of some original research that was conducted by SILA at the end of 2019, summarizing practices of carriers, agencies, third-party administrators, and broker-dealers with regard to background checks. So we're going to identify some best practices and also run through some of the trends that we are seeing. And then, like I said, we will be able to field questions via the SILA forum on the SILA website. So without further ado, I'll turn it over to Greg, and thanks so much for being with us today.
Well, thank you so much. And can you confirm that you can hear me so I don't start speaking for 30 minutes before I realize it?
Well, I can hear you.
Excellent. I'll take an affirmative from anybody that's on the line. Okay.
If anybody has technical issues, we can go through the chat. It looks like we're getting a lot of chat responses there, Greg. So yes, excellent. You are live. You are live.
Okay, so then let's proceed, shall we? Some high-level information about this survey. It was designed to anonymously gather some data about the background screening practices of the groups that were mentioned at the top of the call here, or the webinar here. This is actually the third one that we've done over the course of 4 years. So we kicked this off in 2016, and I think it was maybe about 24 or 25 questions, very basic questions, presented them at some of the conferences in the past, and then did another version of it in 2017, saw increased response rates in 2017, and then we decided to do it again in 2019. As far as what happened in 2018, I'm not quite sure, but I'm pretty sure we just had a ton of information that took a while to present out to the SILA community. So as a task group, we plan on doing this on varying basis going forward, just to ensure that we have all this information, we can present it to the membership. This survey was approximately 30 questions, though, for any of the respondents that do not conduct background checks and things like that, their experience was about 3 questions, because there's logic within the survey to take people to the end so that we don't get we try to avoid irrelevant data within the response rate. So the information we're going to present today is about 133. It represents about 133 respondents in the categories of insurance carriers, agencies, TPAs, and broker dealers. And what we have also tried to do is layer this in with previous year's surveys so that we can trend track this and then allow the membership to try to identify how they might best modify their practices going forward. And last but not least, this was closed on or around October 2019, which I think was around the time of the annual conference. So before I get into any of the details here, I would like to mention that there is a heavy legal notice and disclaimer on this slide deck. This presentation does not constitute legal advice or guidance. You're strongly urged to consult with your own legal counsel regarding any questions of law or how the topics discussed apply to you and the unique needs within your organization. And I would also like to mention that anything that we discuss here does not necessarily represent the views or interpretations of the Security and Insurance Licensing Association, the SILA Foundation, or any of the members of the task group and our organizations, myself included. So One more key piece of information. This was presented at the beginning of every survey to the groups that responded, where we were identifying the most common terms for the purposes of going through this survey. A captive employer exclusive producer was a direct employee or an exclusive provider of the products offered by that carrier or entity. Meanwhile, a broker or independent contractor producer was a non-exclusive individual that sells or markets products for one or more carriers on a commission or fee-based compensation structure only. So again, in the past, we've had confusion when communicating the difference between a captive agent versus an employee versus a contractor versus the Department of Labor definition of employee, and then the Fair Credit Reporting Act definition of employee. So these are all the things where we were trying to level the playing field, so to speak, before going into the survey. So let's talk about the response metrics. Right here, you'll see the 30 questions that were roughly categorized into demographic, qualifier, and then general kind of information gathering questions. Some were in free text, but the blue bars are the response rates. The red bars are any respondent that was either skip the question or based off of their response to a qualifier question was then jumped further into the survey. For anybody that's into this type of data, it's in the survey, we have it. It's very consistent with the previous surveys that we have conducted as well in the structure of the actual survey, which was done through SurveyMonkey. So that being said, let's jump right into the questions here. We have the first question in that survey was, is your entity A? And we gave any of the respondents the ability to answer different questions. Insurance carrier, insurance agency, broker dealer. It was, as far as the graphs, pretty similar to what we've seen in previous surveys, though the most notable thing that was found in this question, at least from our view, was the 2017 survey noted that the carrier population represented 52% or almost 53% versus 59% in this survey, while the agency population was less present within the respondents to the 2019 survey. So when evaluating these questions and their response rates throughout, I think it's important where for anybody that's on the line, whether or not you're a service provider or an agency or a carrier, or depending on the types of business that you do and the majority of the business that you do, you may want to frame that as far as any decisions you may make as a result of this presentation. So some of the next questions we're going to start getting into are going to get into practices as far as who is screened and when. Something I do want to mention is when SILA sent this out to the SILA membership, we didn't specifically corral the background screening or compliance expert from every single organization and make them be the party that's responding to this. So we don't always know exactly if it was the respondent's legal department, their HR, their licensing department that was responding. So you may see some variations throughout this, but the information is still pretty consistent one year over another as we go through. So let's jump into question 2. Does your entity conduct background checks? And by answering no, you'll be taken directly to the end of the survey. We have 118 responding yes, so that's 88, I'm sorry, and yeah, 88.72% responded yes that they conduct background checks. This was somewhat noteworthy as in 2017, the respondent rate was 91%. I believe in 2016, the respondent rate was north of 90 as well. Now, it could be based off of the organizations that are replying. Sometimes in our experience and in discussions that we've had in the task group, it's because the insurance or they rely on maybe a separate entity to run the background check. Maybe they're running a background check's being run through some type of a staffing or placement entity before the individual comes on board. Maybe they have access to it, which does open up an HR can of worms, but we're not going to discuss that right now. But as you see, we did ask an outgoing question to anyone that answered no, and they were not forced to provide an answer. But in these cases, we had individuals replying with that we had a couple of representation of insurance carrier, we had some brokerage and company carriers, and then again, you have the HR department completes it. So it's not always 100% clear who the respondent is versus who might be the organization's czar of screening and compliance practices, but that's what we saw in question 2. Question 3, does your entity conduct initial background checks on? And you're going to see several questions here. This first one's going to be captive / employee / exclusive producers. So for these folks, many of these individuals would fall under the conventional employment context. So we had a response rate of 64% of the 112 that were still eligible to answer this question had responded that yes, they directly conduct background checks on the captive employee and exclusive producers. 8% said no, and then we had 27% that said that does not apply to my entity. Of note, in 2017, a very similar question, and the response rate was for 48.91%. So there is an increase in the respondents, at least the respondents in this survey population, answering that question affirmatively. Same question, but asked of broker and independent contractors and producers, 81%, significantly higher than what we saw in the 2017 survey, where it was 58%. I could speculate as to why, but it would really be something that could be discussed within some of the SILA forums as to why this number is so much higher this time around than in the 2017 survey. Same question again, but through producers placed through a TPA, 13.14% in 2017, while we saw an increase of that of 17.86 in this survey. Again, the not applicable to my entity, that's pretty high because a lot of organizations do not work with TPAs when bringing on producers. So that's something that has increased within the marketplace that we've seen over the last several years. And does your company conduct initial background checks on the producers of a contracted agency or broker dealer? 50% in 2017, 65.77% in 2019. So again, we're seeing things trending upward as far as the individuals that are producing through different entities. Meanwhile, the direct or captive employment screening population has remained somewhat flat. For non-licensed support personnel, this was a new data point that we were looking to collect this year. We have not asked it in previous years, but in previous years we did see in several of the other or text type responses that they would conduct different screenings for non-licensed producer support personnel. So in this case, this is our first data set, nothing to really compare it to. 36% say yes, 45% say no, and then 17% say it's not applicable to their entity. So if you just look at the yes and no's and run that, it's not a 50-50 split, but I don't know, 40-60, doing the math off the top of my head there, approximate. And then these were the other options for that same question. If you do screening on any of the population that's not represented in these previous questions, could you please specify? We have home office employees, persons employed by independent contractors. We did try to omit any place where an anonymous respondent would actually put in another SILA organization's name or else their own organization. So in that case, someone had mentioned the organization that they do the background screening checks for. But we do background checks before submitting the initials or renewals. So we have several different responses here. I think what's also notable is that we only had 7 fill in these optional text fields versus 15 in 2017. Again, we try to take this information and build that to make the survey better when we do it in subsequent years. So now let's start talking about the actual practice of the background screening. This is generally, do you conduct the initial background checks, and it's asking the timing of when a background check is run. So out of the 107 that were still engaged in the survey at this point to answer these questions, we had most notably approximately 50% stated that they run at the time of onboarding, which is the orange graph in the middle there. The trends in this are definitely different than what we saw in 2017, though we did have a slightly new answer structure in 2019. You'll see some of the answers are slightly different, but Regardless, we thought this was notable of the at the time of onboarding, or and then there's also the option of some other time after the initial application, but prior to onboarding. So it would be maybe at the contract appointment, sometime prior to their actual onboarding, but they've actually applied for this. So there are HR concerns here that any organization needs to look at, particularly if you're dealing with captive employees. There's ban the box concerns that organizations should be on the lookout for. And then there's just the general concept of when are you onboarding versus when are you screening, when are you getting the results back, and how does that tie in with the licensing and some of the other things that we're about to go through. But as you see here, if you're doing your screening some on or around the time of onboarding, you're going to be in the largest population of the SILA membership that responded to this. So maybe there's safety in numbers. Now, do you run ongoing or periodic background checks on existing producers? So this is something that we discuss quite a bit on some of our the background investigations task group meetings that we have. There continues to be questions, concerns, curiosity around ongoing and periodic background checks. It could be monitoring of healthcare related services for individuals that are engaged in Medicare. It could be an annual background check. It could be how frequently are you getting this information? How does it relate to how are you collecting disclosures and authorizations, if it's a California candidate versus a non-California candidate. So this is always a can of worms, so to speak, within the SILA membership. That's over the last couple of years, the numbers have been, I think they have gone the same way that the general screening industry itself has gone. So in this case, do you run ongoing or periodic background checks? We have 40% answering yes versus 2017. It was about less than 30% answering yes. So those numbers will, now the respondent population is a little bit smaller here, but still on a percent basis, that's the same kind of things that I think any of the background screening, legal and compliance organizations that may be on this call have seen as well, which is an increase in interest in ongoing monitoring and screening type services. Whether they're done through an outside organization or on your own through the PDB, they still exist. So. Now, this question is newer as far as its structure and response rate. So we tried not to tie too much of the response rate to previous questions. I'm sorry, previous surveys that had a similar question but different answers in it, because it can get a little bit more or a little bit confusing to or misleading as far as trend tracking. But what we have here is this subset of this question is, if ongoing and periodic background checks are run, what is the frequency that you're running them? And they're all over the map here. It's the highest percentage representation is every 2 years or more. And then pretty much when you look in the others, and please specify, there's several items in there that in my first read actually fall into some of the options that are available in the list above. So I would say in comparison to the rest of to the other industries even that I've engaged with, this is fairly consistent, where ongoing screening is all over the place. And if you ask 100 people, you may get 50 different answers. And just a quick note for the SILA staff that's hosting this, I am not monitoring anything that's going to be coming in on the questions. So if you want to ping me within the panelists tab, just let me know and I will make sure I pause and reply if there's something missing. Okay, and then the secondary follow-up question to the ongoing screening was, are you running the ongoing background checks because of, and this was a completely new data point for this survey. Are you running them because of company policy? Are you running that? And these are select all that apply type questions. So the individual numbers are not going to add up to 100% because companies run things for various different reasons. So this was just kind of an open-ended, multiple choice, select anything that applies to you question. The highest response rate is they're running ongoing background checks because of company policy. Now, the question that I would always have is, is company policy a byproduct of your individual regulations that you may be subject to within your industry, state/industry or industries? There is interpretation of applicable law. So, and the example we provided for that was Office of Inspector General searches in the healthcare sectors. About 27%, 28% responded with that is one of the reasons why they would run the ongoing background checks. And then regulatory guidance, which is a little bit different than arguably than interpretation of applicable law, but that was the response rate. We saw that. And then other. I would also like to add that the group added this question as a byproduct of some of the comments and notes that were provided in previous surveys. So again, if you are one of the folks that is invited to take these surveys based off of your position within your organization being one of the demographics that we're looking to collect information from, I would strongly urge you to share as much information as you're comfortable sharing, with the understanding that it is in fact completely anonymous, and SILA nor myself and any of the task group members have any idea who actually submitted this information. Oop, jumping ahead. So question 11 on the survey was, do you utilize an outside company to run your background checks? This is very consistent year over year. There's about a 1% population that does not use an outside party, a consumer reporting agency, a background check to run their background checks. So nothing new on this one. Now the next slide is where we're going to get into not so much the compliance information, but the stuff that the membership seems most interested in every time we collect this, which is what services are you running in your background check? So let's talk about it, because we're probably going to spend, I would think, a couple minutes just looking at this slide and also the next slide, which is a deeper dive on this question. So I'm going to try to highlight the information that that we saw as a task group within this response question. Again, it's a select all that can apply. So the information that any type of respondent would select would theoretically fall within whatever their package of services is within their background screening. So one thing that we did add to this question that for whatever reason had not been included in the previous surveys that we had done, which was the SSN validation and or name and address history search. So and it looks like it was a valuable touch point to put in there, because 80% of the respondents did state that they were on some type of a specific address trace, SSN trace, something like, you know, the different products that exist on the market, whether or not it comes from a credit bureau or some tri-merge address history information. The respondent rate on this is pretty high, which is, in my opinion, good, because that type of information is a critical piece of information to validate before you start running the rest of the criminal history or whatever else you may do. That all falls into criminal history best practices. We've done several webinars over the years through SILA on that subject, but that's what we're seeing with the address trace. Then next came the county, statewide, and federal criminal searches. County criminal searches continue to increase their representation within the respondent population. They're now at 91%. Again, and this was conducted at the tail end of 2019. The COVID concerns, the delays, and I'm going to try to avoid getting into any of that information right now, because that's a whole nother story. But when you look at what are your peers doing and how does your screening program align, we see that the criminal history searches continue to increase. Federal criminal history searches are slightly lower than the county criminal searches. I think that's going, in my experience, that usually ties to a fundamental misunderstanding within some organizations where either they think anything that's going to come back on a national crim or a county could also be found in the federals, or vice versa. I do want to again reinforce with anyone that's listening to this webinar today that a county search is a completely different source search than a federal criminal court search. And I also want to emphasize that felonies don't only exist at the federal court certain level, and there's plenty of felonies and misdemeanors. The vast majority of felonies and misdemeanors are tried within the county courts, and federal courts house felonies and can even house misdemeanors from time to time in rare circumstances. So it could be a misdemeanor that occurred on federal property, something like that. So The national criminal jurisdiction, the national criminal databases, the jurisdictions, those kind of preemptive searches that are often part of your background screening package that then things are developed from, that has also continued to show an increased representation within the respondent rate here. Now, something else that was notable and somewhat predictably notable is credit reports have been declining year over year as far as the usage and the number of respondents that are at least stating that they are using credit reports and requesting credit reports. Much of that, I believe, is tied to some of the stuff we've reviewed over the last several years of the civil and other information that's been the public record information, so to speak, that's been peeled away from the credit reports, and those things are now available within civil searches and things along those lines. So we have seen the credit and financial related services dropping, while public records continue to rise both on the criminal side as well as the civil records. Education, employment verifications, these things stayed relatively flat, but we did add a couple other items in here that'll be demonstrated on the next screen. Another thing I do want to mention is we have fingerprinting. We have, some folks responded with they run debit checks with other carriers, and there are certain platforms out there that house that type of information. So that seems to ebb and flow year after year. So I didn't see any specific trending worth noting in that on this year, and I just went backwards, my apologies. So this is just a deeper dive, like I was mentioning on that same slide before. Tried to line up the 2017 responses with the 2019 responses, with the understanding that the SSN validation process and civil court record searches were not represented in previous surveys. And then you could see the percentage point change there on those. So again, candidate debit balances has, at least in this respondent population, decreased, but it jumps up and down every single year. So I think it's just a matter of the respondents there. Generally speaking, that's still a common product that's being used within the process here. So, and I will pause for a second. If I had thinking and public records processing music to play, I would, but just want to make sure everybody gets a chance to consume some of this information. And again, if you do have any questions, I may regret this, but if you have any questions on the individual services that you see here in the trending, I think it would be relatively safe for us to answer these throughout this webinar. What I do want to try to avoid is any of the compliance-based stuff until we get some of the other, or opinion-based stuff until we get the rest of the task group on to review those. So let's jump to credit reports. I talked about it a little bit. If you're running credit reports, what level of consideration do you give to the information that's being returned? This is a question that we gave it a little bit of a new structure this year, because last year the question was very specific to what level of consideration do you give to the civil judgments and liens that were returned, because it was shortly thereafter that information was removed from from all three credit bureaus' credit reporting. So what we saw was for the folks that are using credit reports, and if you take out the I don't run credit checks population, that last row there of 16 respondents, and just kind of break those numbers down again, 25% say that the information substantially impacts their decision. The approximately 40% say it moderately impacts, 30% say it minimally impacts. And then what's I found a little bit interesting is that population that states that it has no impact on their decisions. Credit reports can have value if they're being used properly and within certain financial sectors. But if you're ordering credit reports and never ever reviewing or considering the information, it may be a larger risk item than it's worth for you. So that's something to always think about. Now, do you provide each candidate? We're going to get into some FCRA information. When I say FCRA, I'm talking about the Fair Credit Reporting Act. For any of you that are not familiar with the Fair Credit Reporting Act, boy, are you in the right place. It is a consumer protection law that's been on the books since the 70s, and it has been modified several times over the years. And it specifically identifies when information can be requested on an individual for their different permissible purposes, and how you can use that information, and what the consumer is entitled to. So that was my 15-second FCRA overview. So this question 14, if you provide each candidate with an FCRA disclosure and authorization, written authorization prior to running a background check. Again, an excellent response rate here, 97.83%. We always have one or two individuals that will reply that they do not. I don't see a lot of that in the insurance business. Most of the insurance packets that at least have come, across my desk have some disclosure and authorizations. Most of them have moved to the standalone disclosure and authorization, some type of a written authorization for them to run the background check based off of different permissible purposes. If you are amongst the population that does not provide any type of disclosure to a candidate and also obtain the written authorization, and you are running background checks, you need to stop doing that right now. So that's my, I'm not a lawyer, but I'm pretty confident in sharing that advice with you. So moving into question 15, do you prescribe to the permissible purpose of employment purposes under the Fair Credit Reporting Act when you're requesting those background checks? So for any of you that have attended some of the sessions we've done live at the SILA annual conferences, this is another big question that exists out there, and we have continued to see the SILA membership improve in the overall compliance rate over the years. In this case, we're running at 96.67%. So the reason why this question is important is if you believe that your organization is using the employment purposes, permissible purpose under the Fair Credit Reporting Act, then it affects a lot of the other steps that you're going to have to take through this process. And also with the understanding that employment is not strictly limited to an individual that is a full-time employee, 40 hours a week benefits. Employment under the FCRA can be interpreted very, very broadly in case law. So. The next question, question 16, what percentage of your candidates are eliminated due in whole or in part to background results? So we have about 90 respondents here. So it's some of these numbers are starting to dip a little bit below the 100. I'd prefer to at least keep the response, individuals responding somewhere in the ballpark of a Family Feud response where we asked 100 people and put the top 5 answers on the board. But that's what we're looking at here. 89 respondents stated that less than 1% of the majority of which stated that less than 1% of the candidates are eliminated in whole or in part due to the background results. I think the most notable thing here, and we actually highlighted this at both the conference and via webinar in 2017, is the number of respondents that had stated that 5 to 10% of their candidates were eliminated due in whole or in part to background checks, and then also the greater than 10% that were eliminated due in whole and part to background checks. So this is much more consistent with my experiences in the insurance and finance industry. I don't want to speak for the entire task group, but when I'm looking at this, you're talking about a somewhat pre-screened population. When I say pre-screened, they've gone through some type of licensing, but there's also still quite a bit of information that can be uncovered in the consumer reporting agency screening context, and we see it quite a bit. So the 1% and the 1 to 3% is typically what I see. If you're doing 5 or 10%, that's much more in the realm of some other industries, manual labor industries. So moving on to question 17, do you provide candidates with pre-adverse initial adverse action notice and a chance to dispute the results of that background check? So what we're talking about, pre-adverse action, so people call it the pre-adverse action letter, the PAAL or PAL. Do you provide them with some type of a notice and a chance to dispute the results? Now, 85% is a pretty good response, a pretty good affirmative response rate on this question. And I say that not because that I'm fairly confident. I'm going to say I'm fairly confident that the 14%, almost 15% that stated no, may not be directly familiar with their process. Now, we do still continue to see organizations that do not provide candidates with some type of a chance to dispute information from the angle of accuracy, but sometimes it's because they're not getting it through a consumer reporting agency, and it's a whole many times, and you'll even see within here that some of the folks that may answer no, they later answer that their background check provider sends it for them, or they're sent by their legal department so that they don't see this. So, but year after year, we've seen this number improve, and now we're hovering at 85% response rate, which I think is critical for the SILA membership in relation particularly to the employment permissible purpose that we saw several questions ago. So that's just a high level interpretation of that question, but even, again, the response rate, you could see we even dug back to the 2016 survey to show it there. 71% in 2016, 75% in 2017, and now 85% in 2019. So if you started doing this as a result of these surveys and the education that SILA has been putting forth, then you should pat yourself on the back, because this is you've probably mitigated quite a bit of risk to your organization in doing so. So let's jump to question 18. Do you provide candidates with an adverse action? This would be the final notice. This would be in an employment context. This is the notification that goes out after the candidates had a period of time to review the results and file a dispute, and a bunch of other things that take place. If you're not using employment permissible purpose, this would just be the notice that states that you have been turned down for this benefit, and if you want a copy of a report, you do X, Y, and Z, and all that kind of stuff. So in this case, very steady responses year after year. This seems to hover around 80% every single year. I'm not quite sure why the needle doesn't move as much on this one as it did on the pre-adverse action, but it could be the adoption of the employment permissible purpose over the last several years. We did see, and I believe it may even be the next question, where if you take the 90 individuals that answered this question and you break that down, then their subset question of, if you're sending the adverse action notices, how long, and again, we tried to use terms that the general population understands here. How long do you wait between sending pre-adverse and the final adverse action notice? That period of time, just for the membership and the folks that are attending this webinar, is very specific to the amount of time that a candidate can review the information and file a dispute within a reasonable time frame and have that dispute resolved. So from the court standpoint, the common interpretation of that reasonable period is a minimum of 5 business days. When you bring in ban-the-box laws and stuff, it opens up quite a bit. But we continue to ask this question. In 2017, the 5 business days was 18.3%, and now we've seen an increase in that response rate from up to 22%. In 2017, the 10 business days was at 22.45%, and that's actually dropped to the 18.98%. But if you look, even in the other please specify responses, many of the responses are, I don't handle this area, I'm not sure. It depends on our employment, the account rep in the field. I'm not involved in this process. So you take those types of answers and you layer them in across the 85 and the 80 and the other percents that we saw in previous slides. And I believe it starts to explain the delta between the overall amount and the amount that, in my experience, are probably closer to compliance than they think, with a handful of outliers. So, and then if you send adverse action notices, what method do you use to send them? This was a standard US mail only. Again, and I do have to mention, with the Fair Credit Reporting Act, the law is very old. It was written in the 70s. I mean, I'm from the 70s too, so, and you know, it's a relative perspective here, but it does not specifically account for email and things like that. Certain technology platforms that are in place now that could allow more efficient communication. It doesn't rule them out, but it's obviously it hasn't been amended to specifically adapt them either. So we have several options that we provided the membership this year. You can see the 2017 comparison to those same responses. And ultimately what we're looking at is 25.74 did a lot of US, basically a quarter of the population did US mail only in 2017. Meanwhile, that has dropped, and I think you'll see the pickup in the email or mail and email combinations. When you combine those two numbers together, the mail and email, mail/email or email only, then you start to really push it into the representing half of the at least half of the membership. The mail-email combination, just in my experience, is something that if you're going to do that, you should evaluate the pros and cons with your legal team, because then you may be talking about two separate notices that are going to a candidate, and one's going to get to that candidate within minutes and another one's going to show up at their house within days. Maybe that's a belt and suspenders approach to risk mitigation on that, but just I would encourage anybody to review those processes just to ensure that you are not doing something that could confuse the candidate, because a confused candidate is the last thing you want in this process. And again, we see those same types of I do not handle and all that other stuff in the parent corp handles it, vendor sends them, that kind of stuff. So we're going to jump into the National Insurance Producer Registries Producer Database, PDB. For those of you that are not familiar with this, if you're not familiar with this, then you may have stumbled into the wrong webinar. I believe most of the folks that are attending this webinar should be familiar with this producer database that is provided by the National Insurance Producer Registry. They are a key member of SILA and a whole bunch of other stuff. Pretty much everybody knows who they are. So in this case, we asked the question, do you utilize the PDB results as part of your contracting process? And we have a 70% response rate. It was actually down compared to 2017, which I don't have any direct line of sight as to why that would be down. So that would be open forward for discussion amongst the group. And moving into additional questions related to the PDB, we ask, do you provide each candidate with an FCRA disclosure and a written authorization prior to running the PDB check? So if you remember, this is a smaller population of respondents. We're talking about 65 respondents now, but we're talking about you ran other background checks and you provided disclosure and authorization. Now you're doing a background check. You're checking the individual's license history and any actions that were taken against them as an insurance producer, and through NIPR, and that is a database of individual state products. So, or states that have fed that information into it, similar to, but not the exact same as FINRA. So, as far as its legal and corporate structure, so to speak. So the question here is, do you provide them with some type of disclosure and obtain a written authorization? Now, the response rate's pretty flat compared to last year, and it is also, when you start talking about this, if you provided a disclosure and authorization at the time of the background screening, and you're also running a PDB check on that candidate, that will typically address any of the needs that you have for that candidate and their PDB result, until you get to such point as if you're going to take adverse action. But so the response rate is flat. This is a hot button topic at every single SILA conference, but the approach and the argument behind it still seems to be pretty consistent year after year. So now for those PDB results, do you provide a pre-adverse or initial action notice? Again, we talked about those pre-adverse notices on your standard background check. What about a PDB result? Maybe a PDB result that's at the time of the background check, or maybe one that might be a little bit later and could still be a consumer report. Are you providing some type of initial notice of, hey, this is what we received back from the PDB and we may not be moving forward with you as a result of it? Do you wish to dispute any of that information? The numbers are flat, if not less desirable than I would think they would need to be. So under any type of permissible purpose. So again, I think that a message there would be to evaluate your processes and figure out how you're taking action. But I firmly believe that there's a lot of organizations out there that actually are following a different process of sending out some type of a notice, but the respondent to this survey is not directly responsible for that. So, Oh, and I just skipped a question. And last but not least is the same scenario, but do you send some type of the final adverse action? Another slight decline here on this from 2017. Not quite sure the logic behind it, but again, I would strongly urge any of the organizations that responded to this and anybody that's on this webinar to make sure that you have some type of a background screening and theoretically an FCRA czar within your organization that can tie the contractor screening and PDB results and license-based screening and things that come from consumer reporting agencies versus policies for things that don't come from consumer reporting agencies, and make sure these things are defined so that you have uniform practices. And oh, by the way, make sure they also know what HR is doing, because you don't want to have multiple processes in for people that are covered from a legal standpoint under the exact same set of requirements. So now let's talk about some of the state-specific disclosures, and this is wrapping it up. And in hindsight, I probably wouldn't have ended the webinar with this level of detailed compliance, but these are the high-risk areas for anybody that's engaged in any type of background screening, particularly if you're doing employees. It's the same thing applies to ban the box concepts for contractors, but not every one of those laws has a reference or a call out to contractors or independent contractors. But generally speaking, does your process include state-specific disclosures and adverse action content for any of the following? And we have some that have just mentioned that they have employees, some have mentioned that they just have producers and contractors, and then some have mentioned that they have both. So you provide it to both, and then the other option of neither. So if you take everything together, you're talking about a 32% rate that responded that you do not have any type of state-specific disclosures. And then the rest have them, and it either applies to employees and contractors, or just employees, or just producers, contractors. But we've seen variations in response rates over the years, so we're trying to fine-tune this question into a universal language for the respondent population. But again, a neither response rate, or neither, depending on where you're from in the US, is 32% versus the neither response rate in 2017 of just under 25%. Ideally, from a belt and suspender standpoint, I'd like to see the insurance insurance carrier and related parties populations get into a slightly lower number there. And this next question is about ban the box. Are you providing any type of ban the box disclosures, and specifically ban the box adverse action content for any of the following? So this would be employees, producers, contracts. Same question, just asking about the local municipal ban the box, fair chance hiring. It was, most of these things were originally lumped under the concept of fair chance hiring. Some of these call out very specifically contractors and non-traditional employees. But this is something that we continue to see it continues to expand across the U.S. and individual jurisdictions, and some of the more complex insurance carrier programs have, I've seen these things built into them, but ideally, I think one would argue that the respondents to the survey are best served having something within their processes, both on the front end with the disclosure and authorization, though don't overlap it with the federal disclosure stuff, or on the back end too with your anytime you're going to take an adverse action. So, and now jumping right back into your internal practices, these two questions. This is a two-part question now. Who is within your organization? Within your entity reviews or adjudicates the majority of the background results on licensed individuals, your producers? What we have this year, we did separate it because last year there was a lot of other responses where they said, well, if it's really bad felonies, then legal does it. If it's not, then if it's just routine stuff, then it's our licensing or contracting. So in this case, we have the highest representation within the licensing and contracting team adjudicating background related information when it's processed. We still continue to see the sales team at 2.35%, which in the past we've even stated that sounds like a conflict of interest. But if you have a high producer that's also has committed a lot of acts that may harm your organization. Maybe the sales team is sales and distribution team is not the group to evaluate the risk to the organization. Perhaps licensing, contracting, compliance, legal. But in this case, we continue to see the response rates are I would say fairly predictable here. We did add a committee or team made up of representatives from 2 or more different departments, and that does represent 10% of the respondent rate on this. So that's and that makes sense with what we see. Now, the same question, but this is for your escalated background results. So we didn't define escalated, but it seems to be it was generally interpreted as something that immediately posed a notable risk to the organization. Could be offenses under 1033 or theoretical. Maybe it's an offense that sounds like it might be one of the federal 1033 offenses that you can't allow them to provide or be a producer under, or some other type of scenario. So compliance and legal, again, ran away with most of the escalated stuff. Licensing, contracting is in there, as well as a committee. And then operations management will, in some cases, 2 respondents stated that operations management will handle that, versus the previous slide, just flipping back to that, operations management is not evaluating initial background checks on producers based off of what we're seeing here. And this is the last question of the survey. So, and I'm actually pretty surprised that I got all this in about 50 minutes. So, does your entity have a defined appeal process for disputed results and decisions? This is not specific to the Fair Credit Reporting Act. This is more like an individualized assessment, perhaps, or something that allows an individual to say, look, I understand the information that was reported on me, and I reviewed that, and that information is factually accurate, but I still think you should hire me, and here's why. That's the general intent of this question. Based off of previous survey responses, we tried to build this in, and we have a 57% response rate. So that, let's say that the majority of the respondents, the 84 respondents, do have this type of process in place, though that number is down compared to 2017. So not exactly the direction that I would think that this would be going, based off of trends that we see outside of the SILA membership and in different industries or verticals. So, and last but not least, before I stop talking for a second here, the question 30 was just open text. And I think it's also important that we display this, because this is stuff that we may be discussing on the forum. We also have a task group that we try to meet monthly, and we go through and we update the best practices handbook with different information regarding background screening practices. But these are all questions that when they're provided to us, we try to take them into account, whether it be in a webinar or in a maybe an open QA webinar with the group, or one of our monthly calls, or one of the sessions in the fall this year, assuming we all get a chance to travel by that time. So I'm not going to read these line by line, but you see it's a lot of the same questions. How does it relate? How do things relate to the Department of Insurance? How FINRA versus FCRA versus the NIPR and their PDB? What felonies are intertwined with the Violent Crimes Control Act? VCCLEA, that comes up all the time, and things about SSN searches. So very, very consistent questions that we see throughout. So at this point, I'm going to I guess hand the mic. So I'm going to pass the mic here, so to speak, back to SILA. But I do want to mention that Diana does a wonderful job for us on the task group and coordinating our calls and working with the surveys. And we have a great group of folks. I want to say it's around maybe 15 or 20 individuals that are part of our part of the task group, and we engage as needed. And these are just some of the things that you see on the screen that we do. If you're interested in, if you're a SILA member and interested in being a part of this task group, you don't have to say or do anything, but all voices are welcome. So.
Awesome. All right, this is Cindy again. Going to bring us to a close. First of all, thank you, Greg. That was excellent. I think the best work we do is our original research, and this is particularly valuable, I think, because what you've done, it represents multiple years. So now we can look back at similar surveys from years gone by and just see how the industry is moving. So excellent work to you and the task group and the subgroup. So thank you for sharing these results with us. As you guys know, this webinar has been recorded and it will be available on the Foundation YouTube channel sometime in the next 30 days. If you go into the chat, you can find that website. And then, as you also probably know, SILA Foundation provides these webinars every month, free of charge and on a shoestring, and very dependent on volunteers like Greg. So it's part of our mission of education and outreach. So if you did receive some valuable takeaways from today's presentation, consider making a donation to the SILA Foundation. You'll be receiving a post-webinar survey, so please respond to that candidly and help us improve and keep your eyes peeled for future webinars. So that's everything I have. Thanks again, Greg, and thanks everyone for attending.